Hi everyone, I'm Advocate Akhil Solanki, Associate with LEXIS and Company. So today we're going to discuss whether a conviction under IPC 498A sustain if marriage is declared null and void. So the Supreme Court on February 9 set aside the conviction of three persons under Section 498A of the IPC. It observed that the conviction would not be sustainable as the marriage has been found to be null and void under Section 498A IPC. A husband or his relatives can be sentenced to a jail term of 3 years for subjecting the wife to cruelty. In this case, it's a case from Tamil Nadu where a woman had filed complaint against her husband and his family members before the police, which led to the investigation and filing of a charge sheet under Section 498A IPC and Section 3(4) of Dowry Prohibition Act. Besides, the husband, the mother-in-law, the father-in-law, and the brother-in-law were also accused in the case. However, all four accused were acquitted by the trial court. The state and the woman filed revision petitions against the acquittal. A single bench of Madras High Court allowed the appeals in 2011 and convicted three accused, husband and his parents. The decision was challenged before the Supreme Court in 2012. In a turn of events, the marriage of the couple was declared null and void by the Madurai bench of Madras High Court in February 2021. The couple had married in December 2003 as per Hindu rites, and it is alleged that when the couple were living in Chennai, the husband found out that the woman was not Hindu but a Christian. In a case seeking divorce in 2005, he alleged that his wife and her family were Christians and had misrepresented their religion when the marriage was performed. Further, the court also said one may be inclined to agree with the view expressed by the smaller bench of the Supreme Court, but judicial decorum and propriety and the well-settled rule with regard to precedents require that the ratio of the larger bench be followed. So on December 12, 2022, the police, in response to a writ, told the Delhi High Court that it would take into consideration the ruling at the time of registration of FIR on a complaint alleging of offence under Section 498A IPC. After the person against whom the complaint was filed argued that since the earlier marriage of the woman, his second wife, was not dissolved by decree of divorce in accordance with law, their marriage is not valid. So thank you. See you next video with some more information.